You are listening to the Game Informer Show. I'm your host, Matt Helgeson. This is actually a special edition podcast of the Game Informer Show because this week, or was it late last week?
Early this week.
Early this week.
Yes, on Monday morning.
The Supreme Court handed down a, I guess, fairly landmark decision about video games. We've been covering the story extensively, most particularly Matt Miller, who joins me today.
Hi there.
He's done a lot of our coverage, both online and in the magazine, about the case. For those of you that weren't familiar with the case, it was basically a California law that was started by a guy named Leland Yee. He's a California lawmaker, and it was sort of a California-specific system of labeling and enforcement of violent content and sexual content in video games that was going to be separate and different from the ESRB, E for everyone, M for mature kind of system that we're all familiar with. I guess, Miller, you've covered the case pretty extensively. Why don't you just sort of tell our readers what the basics of that were?
Yeah, sure. Matthew Cotto and I actually have spent a lot of time in the last year following this case pretty extensively for the magazine and for the website because I think you're right, Matt. It was a landmark decision not just for video games, but for the wider world of entertainment mediums. If you think about what they were trying to do here in terms of legislating and making illegal certain types of expression, there is a potential slippery slope there that can pass over into movies and books and on a wider level implications for the rights of minors in general. Anybody who is 18 and under, their First Amendment rights were really at issue here. And so as far as the particulars of the law, it gets a little bit complicated, but the easiest way to explain it is that is what you said, that it was an attempt to have a different regulation system that was not actually terribly clearly defined in the law. It just said that games that had particular content, particularly violent content, and they used some descriptors in the law that seemed to try to indicate what type of violent content would be included, would need to have an additional sticker on top of, or I guess instead of the ESRB, one or the other, that labeled the game as an 18-plus game, and there would be a $1,000 fine per violation of that for any retailer who sold a game like that to a minor. And similarly, if I'm remembering correctly, there was a similar fine for a publisher if they mislabeled the game, like if they put out a game that should have had an 18-plus sticker and it didn't.
Right, and it was correct me if I'm wrong, but it was incumbent upon the manufacturer, the publisher of the game, to sort of self-regulate and basically decide for themselves what the content descriptors and stickering situation should be on their own, right? Not through the ESRB.
Yeah, I mean, part of the thing that was so unusual about the law, and now as we can look back in retrospect, we can understand that this is probably one of the reasons the thing got shot down, is the idea that whole concept was left sort of up in the air. It was not clear whether California as a state would establish its own regulating body that would take a look at the games as the ESRB does, right? Like the ESRB gets in these games, it has a constant communication with the publishers of these games to try to determine whether there's going to be an E on that box, a T on that box, an M on that box, or whatever. And there wasn't anything in this California law that seemed to particularly describe how that process would work. And so you're right. I think the implication was that a publisher would kind of be on their own to make that call. And so that was sort of what was going on there. What was more significant about the law, though, was the fact that unlike in, let's say, the way that CDs are labeled or the way that movies are rated when you go to the theater, this was a system that was fundamentally making it illegal to purchase those games for minors. Not just something that was a self-enforced thing, which is actually what a lot of people don't understand, that like R-rated movies, it's not illegal to let a kid into an R-rated movie. It's just that there's a very strong self-enforcement policy in place.
The film industry, much like we have done, or the game industry has done with the ESRB ratings. It has just come up with, or many years ago, came up with the R, PG, G, X system.
Yep, and so that's the way that the system's been working. And to be honest, the ESRB does a pretty good job of it. I mean, even by the FTC standards, the Federal Trade Commission looks at this at the ESRB and says that it's doing better than other entertainment mediums at keeping M-rated games out of the hands of minors than other industries are at keeping potentially objectionable material away from kids. That it's I think somewhere in the range of like only 20% of kids who are able to get access to these games when they shouldn't be. And that's even though that is a significant margin, it's lower than what it is for like kids getting into R-rated movies or kids getting CDs that are labeled with a parental advisory sticker.
Yeah, and the real, I think the thing that the industry thought was probably the most scary was, I believe that the way the fine structure was going to work is that if you had been deemed after the fact to have mislabeled a game or had not put that sticker on a game that should have had it, according to this nebulous, sort of system of enforcement that they didn't really describe, they could actually levy huge fines. Huge fine. Was it $1,000 per unit sold?
Exactly. And so you take a look at a game like Call of Duty or Halo or something like that, and if a game like that had been mislabeled, like a game that sells that number of units, you're looking at a potential legal settlement that could bankrupt a big company like Ubisoft or Activision or EA.
Right.
Or
and actually, to use a something that actually happened. The hot coffee incident was Grand Theft Auto San Andreas. There was a game that they thought met the M-rated mature content description. People figured out a way to unlock this content that Rockstar didn't intend to be seen. I have no doubt that if that would have happened, if this law was in place, that Rockstar would have gotten fined per every unit of Grand Theft Auto San Andreas, which up to that time had probably been one of the largest and fastest selling games of all time. So you're talking about if they'd sold, I don't know, 3 million copies.
Yeah.
That you're talking about a $3 billion fine.
Yeah,
and Take-Two could not bear a $3 billion fine.
No, I don't think any company could. At least I'm not a legal expert, and we should be clear about as we're talking about this that our understanding of this law is is governed by the fact that we're journalists and not legal experts. But that actually kind of gets to the point that like there was an expectation here of an understanding of a relatively complex law that everybody in the video game industry was going to have to try to figure out how to deal with and understand. And, and again, we're never going to really know what sort of legal cases and things like that might have pumped up because, as we found out this week, the Supreme Court says that this law is not constitutional, and we're going to go on from there.
Yeah, and I think it was seemed to be perceived as a very strong victory, at least in all the reports that I read, and in statements released by the ESA, which is, for people that don't know, is the Entertainment Software Association. They are effectively, I guess, the governing or the industry body. They do a lot of lobbying on behalf of the industry. They fund the ESRB and the rating system, and they deal with a number of different issues. Whether that's piracy or trade issues or intellectual property rights and all sorts of things. But they have sort of been the organization that has basically led the battle against this and probably funded through the dues paid by the various companies in the industry, the legal team and all that. So it seemed like by the statements that they released that they were pretty happy that they felt like it was a fairly strong decision.
Yeah, I mean, at the end of the day, I listened in on a press conference that the ESA had just after the decision on Monday morning. They had a big call-in press conference where Michael Gallagher, the head of that organization, spoke, and the lawyer who argued the case spoke. And they said something that is to the point, which is that, like, whether this was, a unanimous decision or a 5-4 decision in the majority, or what it ended up being, which was a 7-2 majority decision, at the end of the day, it doesn't make a huge difference. It is the law of the land. Once the Supreme Court makes a statement in the majority and like has that opinion out there, that is the guiding principle by which other judges, if there ever comes another law in the same vein, comes up the chain, this is the authority that they look to, is this decision, not the minority opinion in that decision, but the majority. But that said, it was a strong decision. It was, 7 of the justices saying that the law should be struck down and 2 citing against. But it was an interesting decision, as Supreme Court decisions go, because you actually had 3 opinions. You had the majority opinion of 5 justices that were represented by an opinion written by Scalia, that were basically shooting this down on First Amendment grounds, like that this is just fundamentally an attack on free speech, on the free speech of minors, on any number of constitutional issues were being violated by the law. You had 2 justices who dissented, who I believe the opinion was written by Thomas.
Yes, it was written by Clarence Thomas. I think Bayer also signed on to that dissenting opinion. And
that was a really, you can read these opinions online, by the way. They're really interesting. But that opinion was fascinating to read because it basically came across as Thomas using sort of originalism and his understanding of the way the Constitution was when it was written to say that minors shouldn't have First Amendment rights fundamentally, which is like, think about that for a second.
He seemed to have sort of a axe to grind that was sort of a bit. He seemed to use this case as sort of at least when I kind of looked through it, he seemed like to be using this case to sort of maybe go back to a particular acts about minors and their lack of First Amendment rights that he sort of wanted to put out there. And Scalia actually kind of, I think, smacked him down a little bit in his majority opinion.
Yeah, there was definitely
which is interesting because they're generally on the conservative wing, and those guys, I would say, probably vote together
a lot
or quite often, and so it's odd to see, say, like Bader Ginsburg and Sotomayor being on
with
the same
Scalia,
side,
right?
and having Thomas and Scalia be on the opposite side of the issue, which is sort of an interesting dynamic.
Yeah. Politically, it was a really interesting decision because you had conservative and liberal, traditionally conservative and traditionally liberal justices who were siding together on this First Amendment issue. So anyway, you had this decision that was basically, or this opinion from Thomas that was like, well, all this stuff is moot because minors shouldn't have any First Amendment rights, and which just sounds a little bit crazy to me personally. That would mean that like a parent would have to give permission for a child to go to church, a 16-year-old to be able to go to a church that they wanted to go to, or to go to a political rally, even if that political rally was for, let's say, children's rights. And so, it was really weird. But perhaps the most interesting part of the whole equation is that there was a sort of in-between opinion, a concurrent opinion, I believe they're called, that was it written by Alito, I think?
Yes, I believe so, the Chief Justice.
And that opinion seemed to kind of come down a little bit on the side that like it definitely sided that like the law should be struck down. But rather than fundamentally dealing with like the First Amendment side of it, it kind of implied that like maybe there's a law out there that could be written that would meet with the legal requirement to allow a state to do this sort of thing.
Yeah, it'll be interesting to see how it plays out. I think in the near term, everyone pretty much agreed, though, that the industry was very happy with this result.
No doubt.
The ESA was I think, probably thrilled that the majority was as strong, 7-2, as it was, and that the lead opinion written by Scalia seemed to be as strongly worded in favor of striking down the law as it was. So it'll be interesting to see how all this plays out in the future. But I think in the near term, what gamers should take away is that I think following this decision, video games status as protected speech is much stronger. I think video games as an art form is much stronger in terms of being recognized as such, and speech that's important and under the protection of the U.S. Constitution. So I think these are all really good things. So yeah, thanks, Miller. We appreciate you coming on to kind of give some of your insight, because I know that you followed this case probably more closely than anyone else on staff. And next up, actually, we're going to be talking to someone from the ESA who has been very familiar with this case and helping them sort of get their message out. His name is Rich Taylor. He's worked at the ESA for a long time and very familiar with the case and their efforts in contesting this law at the Supreme Court. Rich is going to be up in the next segment after a quick break, so stick around for that because if anyone can obviously speak to this case, the ESA has been the lead organization, so it should be interesting to hear his insights on the matter. And we are back on the Game Informer podcast. We are happy to be joined by Rich Taylor, and Rich is actually the Senior Vice President of Communication and Industry Affairs at the Entertainment Software Association. As we mentioned in the first segment, the ESA has sort of been, for a number of years, the main industry body in the video game industry, and has sort of, I guess, spearheaded efforts to combat these type of laws and also present legal challenges to these type of laws, as we just saw at the Supreme Court. Rich, thanks for joining us.
Thanks for having me.
I was curious, what in your role, what was your involvement in the case? Was it sort of getting the message out to the general public and the press, and how involved were you with the case?
Yeah, that was primarily it. There was a lot of interest and a lot of focus on this, not just from the game community, but from legal scholars, legal publications, First Amendment rights folks, and then interest from people from other creative industries because of the potential impact on them. So we spent a great deal of time getting our messages out about why we felt the law in question before the court was unconstitutional and why we thought it was also unnecessary. And that took a whole lot of time, a lot of energy, but it was well worth it because the court looked at the merits of the case, and we feel validated what we've said all along, which is that video games are a form of creative expression and deserving of First Amendment protection.
Rich, you mentioned something there that is really interesting to me, which is that certainly the case has some incredibly broad implications for the video game industry, but also for the wider First Amendment proponents and for other entertainment mediums. I'm curious, about some of those conversations you had with. Were you contacted by the folks who, sort of the similar bodies over in movies and music and that sort of stuff?
Well, it's part of the process when you have a case at the Supreme Court. Both sides contesting a case try and encourage what they call amicus briefs, which is friends of the court briefs, and those are folks who write with endorsing one side or the other to the court. And the California side had a very few such documents go in, and we had documents from over 180 different folks and groups, and those included social scientists, they included high-tech folks, they included folks on the left side of the political spectrum, folks from the right side of the political spectrum, and they did include individuals from the creative industries, including movies and music. So, yes, you're absolutely right.
Talk a little bit about your legal team and who they were, and are these the lawyers that you guys have used over the years, or when it comes to the Supreme Court, do you actually have to go out and find people that sort of specialize in or have been before the court before? How did you guys work that?
Well, we did turn to we have an in-house general counsel who takes the lead on sort of the effort from a legal perspective, but our lead attorney was a gentleman named Paul Spitz, who has argued, I think, either 12 or 13 cases before the Supreme Court. And there are a handful of sort of top-level practitioners who argue before the court, and we were determined to have one who was outstanding. Now, Paul has also worked with ESA on behalf of this industry in other cases before, so he wasn't just a hired mercenary gun. He actually was very passionate and believes in this a great deal, and we felt great having him on our side. He did an amazing job in November the oral arguments, and he did an amazing job in preparing the case itself. So we felt not only did we have the side of right going into the case, we also felt like we had a pretty outstanding team at work on the legal front.
I was curious because obviously, these cases have to work their way up over quite a long period of time in lower court systems to get to the Supreme Court. When you actually get to the Supreme Court, is that sort of a fundamentally different process in terms of how you argue things and how you present a case? Is it sort of the same as it is in the lower court system?
The Supreme Court is like no other place you'll ever see, and if anyone's ever in or around the Washington, D.C. area, and if the court's in session, I can't recommend enough that you go and see a case argued, because it is it's a fairly amazing process. And this court, unlike most courts, first of all, has there are 9 justices up there, 9 of the best legal minds on the planet, and you prepare to present. In this case, our attorneys prepare to present. They may get 10 words into their presentation, and the questions start to come, and then another question starts to come, and then the justices may argue about a matter, and then it comes back to the attorney, and it's on a clock. I believe it's 30 minutes aside, if I recall, and it stops. When it's done, it is over. And it's almost theater, except that the stakes are so high. But it is really something to see, and you don't know for sure when you're listening in the court how justices are going to actually ultimately vote on a case. You can maybe get a sense of it, but sometimes they are just sparring just to see what they can find out. But coming out of the case, we just felt really good coming out of the oral arguments that just our side performed very well, and in many of the facts within our legal briefs and in the sort of public space that we've been pushing as messaging was being heard within the courthouse, it seems. So we felt like we had taken our best shot, but of course, until this past Monday, when you actually get a decision, you can't possibly count those eggs until they hatch.
Yeah, this following the Supreme Court case was a real education for me, having not followed anything that closely from the Supreme Court before. Just because of those reasons you mentioned, it really is almost like a theater at certain moments, like the drama of like reading or hearing those oral arguments and the sort of stakes that are at play, and these really big ideas that are being argued by some of the greatest legal minds of our time, right?
Mm-hmm. Yep.
And then almost, if not more interesting, is the stuff that came out on Monday. These opinions are just these kind of fascinating glimpses both into the legal system and into kind of the current state of First Amendment law. And
I was going to say some of the greatest legal minds of our time and Clarence Thomas.
Yeah, I mean, it's really weird. I mean, you see these different ideas presented and argued, and you see the justices sort of arguing with each other in these ways that come across sometimes as like really snippy.
Mm-hmm. It's true. It's true. And they come to the courtroom, prepared. They aren't seeing this stuff for the first time. They're not, prepared for the first time. They didn't cram for it. They know it, and they come right into it. And this is a very big First Amendment case. If you look at the courts, the cases they looked at during this session, this really was one of the more significant ones that they were going to consider. So they were locked and loaded when they came into the courthouse. There's a great book I actually read a few years ago called The Nine by Jeffrey Toobin.
Okay.
And I read that book, and I was so amazed. It's about the 9 justices of the court and sort of the process of them becoming justices, and it kind of takes you behind the scenes. It's a whole different way of looking at it. Anyway, I read that book and was so blown away by it. That's the first time I decided right then I had to go see the court actually in action. And it's almost as if the book was almost like a program you got going into the theater. Like we said, it was read. I mean, they were doing exactly what the book said they were doing, and their postures and the way they, who was animated, who wasn't, who was reclining. It was just fascinating to see it in action. So it's a great book, and if you plan on going to see a case at some point, it's a great sort of way to sort of prepare yourself. But it is something to see, and it was amazing to hear this industry and hear video games being talked about by those justices and being talked about, largely knowledgeably. I mean, you see references to, Mario Brothers and you name it within the courthouse. It's a pretty amazing thing.
Yeah.
I was curious, you said it's a little hard to sometimes read the tea leaves based on the questions they're asking and things like that, but having sort of observed their questions and the different justices, did you have a pretty good idea of what the final count of the decision, the 7-2, would be, and who would be on what side, or were you surprised by anyone switching?
No idea. I mean, you can take your best guess, but we had folks who are court experts and legal experts, and they're all over the board. We were generally very confident, again, that we would prevail, just because we felt we were on the right side of the argument itself. But counting it and who would go where, that's an inexact science, as it turns out.
One of the things I was most interested to talk to you about, Rich, was I know that in your position at the ESA and sort of the official position of the organization is as it should be, is talking a lot about this was a clear win for the video game industry as it was, and a 7-2 margin is a big one. But it was interesting in that there were really like three opinions issued here. There was the majority from 5, but then there were these two others that were both that both had something else to say. And I wonder if you could speak a little bit about both of those, both the kind of concurrent opinion from Alito that ended up siding on the video game industry side, but had something else to say about it, as well as that dissenting opinion.
Well, I mean, again, what's so critical at the end of the day is what was the majority opinion.
Of course, sure.
That's the law of the land. And we prevailed, obviously, in a very broad fashion on that. I think there was obviously a dissenting opinion by Justice Breyer and Thomas, who just basically disagreed with the majority. And if you, not to get too deep in the weeds, but if you do look at the majority opinion and you look at the third footnote, Justice Scalia pretty much eviscerates Justice Thomas's logic on how he came to the disagreeing side. I mean, it is a clinical dissection and obliteration of Justice Thomas's legal standing on that. So I really, it's actually, and Justice Scalia writes I think you mentioned earlier, he writes in a very readable, colorful way. So it's actually a very readable document. But the third footnote in particular goes at the dissenting opinion. Justice Thomas would have upheld the law on the ground that minors historically have lacked First Amendment rights independent of their parents, and the majority opinion obviously expressly disagreed and went to town on that sort of foundation. Now there was another opinion, a concurrence they call it, that was by Justice Alito and the Chief Justice Roberts, who were also voted with the majority on the larger victory opinion. And that opinion agreed that this particular law was unconstitutional, but only because it was unconstitutionally vague. They kind of rejected the overall majority argument that the law was necessarily defeated by what they call strict scrutiny, and Alito and Roberts asserted that changing technologies made it premature to issue those kinds of judgments. Like they kind of wanted a wait-and-see approach because things are changing so fast. But again, the 7-2 overall opinion was a knockout blow, we would term it, to those who think government has a way to regulate creative expression. Government can take the place of parents in determining what kids can and cannot watch, and that somehow video games are an inferior being when it comes to who's eligible and what's eligible to have First Amendment protections. It just decided those kinds of assertions were, got the way of our protests against comic books and dime store novels and gangster movies and shooting Elvis Presley from the waist up and on and on and on, where this country's had a hysteria over a new form of entertainment, new form of media, which in hindsight just looks silly. The justices, I think in this case, looked at this and said, we're not going to be one of those, we're not going to be a court that looks silly. We know where we are in this.
Right. You just termed it a knockout blow, and that was one of my questions, is that obviously over the past, I don't know, decade, five to 10 years, you guys have really, seems like you've constantly involved in one state or another, or one area of the country or another, combating laws that were, maybe not identical to the California law, but similar in intent. Do you feel that this now effectively sort of slams the door shut on those sort of attempts? And do you now see in the future that you won't have to spend as much time kind of in court and in different states fighting those type of things? Or are people still going to attempt and just not be successful, or how do you see that going?
Well, I mean, we would hope that this ruling would put an end to attempts to restrict content that the High Court has, clearly deemed protected free speech under the Constitution. So this would be the 13th federal court decision affirming that video games are deserving of this protection. So it's 13 times it's been asked, 13 times it's been answered. Nearly a decade of sort of jurisprudence on the issue has resulted in now 13 such decisions. So if you look at it, the state of California spent 6 years, hundreds of thousands of dollars defending a law that multiple courts, including the Supreme Court, struck down. So we would hope that legislators out there would stop wasting time and public funds seeking unconstitutional restrictions on video games and focus instead on legitimate priorities that are out there, legitimate concerns that are out there affecting people's everyday lives. Now, we do invite those who are honestly and truly want to help find ways to educate parents about games and access to games to work with us and raise awareness of the rating system that applies to video games. The ESRB rating system, which has been lauded by the Federal Trade Commission as the gold standard of entertainment rating systems. Work with us to do PSAs and communications with your constituents so that parents know the tools available to them and the ratings, and then the fact that retailers are partners in helping keep these M-rated games out of very young hands, and the fact that your consoles have controls on them as well. Help us remind parents about that and how to set those controls. So if that's where your focus is, we're willing to work with you, but we would encourage and hope that legislators would see the court's ruling as a clear sign that it's time to stop these kind of unconstitutional pursuits and instead maybe turn their attention towards sort of more real everyday concerns that people have, like jobs and the economy, for instance.
You're talking about some interesting points there that brings up a question for me, which is that as much as I'm sure the ESA and everybody over at your organization is celebrating this decision, this well-deserved sort of hopefully respite from having to deal with these sorts of cases for at least a short time, and hopefully for a long time, the question that you could say might be sort of the fundamental root cause of all of this stuff, I think, is still out there, and I'm interested to hear what the ESA as an organization. You talk about things that parents can do, things that lawmakers can do. Are there things that the ESA can do or is going to be doing moving forward to try to address from a self-regulatory perspective the same things that these laws are trying to deal with from a legal perspective? I mean, in a weird way, you guys at the ESA kind of have some similar goals, right? Like, you don't necessarily want M-rated games in the hands of minors, right?
Mm-hmm. Well, we want parents to decide which entertainment their children play. In the same way, an R-rated movie, they decide whether to buy a ticket for a 15 or 14 or 16-year-old to go in.
Right.
We want them to make the determination best for their family.
Sure.
I don't think government does that.
So are there things, are there new directions that the ESA is considering to, as you mentioned, the FTC has lauded the ESRB as being a really strong system and really doing a great job, but there certainly is still room for improvement to continue moving forward. Are there things the ESA would like to try to do to make the ESRB be an even stronger organization to kind of keep control in the hands of parents and that sort of thing?
Well, I think it's a fair question. I think what the good news is, as an industry, the video game industry has been a leader already before this particular case and before many of these others. We've always been at the forefront of trying to provide information to parents, to provide tools to parents to help them monitor and limit the kind of games their children can play. So we're just going to keep doing what we do, keep trying to find ways to improve it, keep finding ways to help get the word out more broadly. So we feel very good that we're already the leading industry in this regard, but that doesn't mean that now that we have this court case we're going to rest on our laurels or dial it back. And if anything, you're going to see more of us out there, because I think there's maybe an appetite, because of so much attention on this case, there may be an appetite from state legislators and state and local media to learn more about the rating system and perhaps help us tell the story more broadly.
Leland Yee, who was the architect of the California law that was just struck down by the Supreme Court, he said he felt that this decision was a victory for corporate interests over the interests and well-being of children. How would you respond to that statement?
I think for him to think that Justices Sotomayor and Ginsburg and some of the other on the traditional left side of the court are somehow corporate toadies, it puts very much out of stride with the reality of the record. What the justices were pro-First Amendment, pro-parents' rights, pro-creative expression, and that's the extent of it.
I guess just looking ahead, I wanted to just ask you about, in terms of enforcement and these things, what areas do you think that right now are the things that you probably most need to work on and improving in specific in terms of enforcement of ratings and those sorts of things?
What does the industry need to work on?
Yeah.
I think the tools are out there already. I think we're doing a pretty darn good job of it. I think most of it is just an issue of awareness at this point, and just increasing awareness and what the ratings mean. I mean, now there's apps you can put on your Droid or iPhone or any other handheld device, so the parents right in the store can find out right away what a title is rated and why. If it's an M-rated game, it gets kind of blocked when it's scanned at the register and asks for identification. As I mentioned before, the consoles have controls built into them. So there are a lot of tools out there, and much like a seatbelt in the car, you can provide it and you can tell people about it. Ultimately, they have to decide to use it, and we really hope parents do make use of these tools.
Great. Well, thanks so much for joining us, Rich. We really appreciate it.
Oh, it's my pleasure.
And congratulations. I'm sure you guys have had a good week, and I'm sure there's a sense of relief around there.
It sure is, but I think it's anyone who loves video games and loves the First Amendment has a reason to feel that congratulations this week. It's a good week for all those kind of folks.
Absolutely. So with that, we're going to sign off for the Game Informer show. Next week we'll be back with a regular episode, but we felt like this was sort of a historic moment in games that we should have a special edition devoted to this, because it is really probably one of the most important moments in game history. So thanks again, Rich, and we will see you all next week.